Good morning, Ms. Jones. My name is Mary Lee Ratzel. I represent a gentleman by the name of Tommy Tennant, who's involved in a lawsuit against the ABC apartment company. And I understand that you are also a tenant that lives in that particular building that Mr. Tennant resides. And you've seen the deteriorating conditions there. And it's for that reason that I would like to arrange, if possible, an opportunity to take your deposition with regard to Mr. Tennant's lawsuit within the next few weeks.
I don't know what I can add. What's a deposition anyway?
Well, a deposition is a method that attorneys use in a lawsuit to investigate and interview witnesses who might know some particular facts about the case. And it helps us, in essence, prepare for trial. It's really a question and answer interview. I would be asking you a series of questions about the building. You would respond to those questions, and then a court reporter would be taking down the question and answer and preparing a transcript for us. And then we use that transcript to help us prepare for trial. And it's also helpful in determining whether or not we're going to call you as a witness to actually testify at the time of trial.
Okay, the trials, testimonies? That sounds pretty serious. Do I need to get a lawyer?
Well, I represent Mr. Tennant in this case, and so I can't counsel you specifically as to whether or not you need a lawyer, but you're really being called in this case for purposes of just providing facts. You know, you're not a defendant in the case, and I would just be asking you your observations with regard to the building. However, you certainly have the right to contact an attorney or give an attorney a call and ask them any questions that you might have concerning whether or not you need representation in this matter. As to the deposition itself, the reason we need your deposition and why we want to ask you these questions is Mr. Tennant has to be able to prove his case in court. He has to be able to show to the judge just exactly what the conditions were in that building. And so your testimony would be very important to us in terms of establishing certain facts with regard to your observations, and that would be, you know, is the building deteriorating? Is there a problem with trash accumulation? Have you noticed problems with roaches, for example, or mice or rats on the property? What are the conditions of the elevator? Those would be the type of questions I would be asking you in your deposition.
Yeah, okay, I guess I can do that, but how long is it going to take, and who's going to pay me for my time? If I don't go to work, I'm not going to get paid.
Right, I certainly understand that. What we try to do when we set up depositions is we try to set them up for a convenient date and time that works with your schedule. And I would say you probably should allot 2 hours for your deposition testimony. With regard to paying you for your time, we would cover your expenses, for example, your parking expenses associated with coming down to my office for your deposition. And then the law requires that we pay you a statutory witness fee, and that fee is $40.
$40? I'm going to lose $200 if I don't go to work for a morning. So if you want me to come in, you're going to have to do better than that.
Well, I understand, and it is a frustrating process for fact witnesses is when you find out that the law says that the witness fee is $40, but we'll do whatever we can to accommodate your schedule. In other words, I don't want you to necessarily have to take time off of work. We could set your deposition up after you work in the evening, or we could set it up for a Saturday. We'll do whatever we can to make it convenient with your schedule.
Okay, listen, my assistant just called on the other line, and she says the lawyer from ABC Company is on the line. Should I talk to them?
Mary Lee, when you find yourself in a situation where you're calling a witness to an event or something like you did here in the situation with the apartment house, how do you deal with the problem of a lot of people just don't want to get involved, or they prefer to not show up?
I think what you really have to do, John, is engage them in some conversation. And their immediate response is that they don't want to talk to you. So you try to engage them a little bit by, for example, in the scenario that we had, I may have gone a little bit further and talked to the witness about the fact, well, you've lived in this building, try to get her to tell me some information about the building, such that, you know, she starts saying, yeah, you know, I haven't been real happy about the condition of that building either. And then they sort of get into the case a little bit in terms of saying, yeah, I can help support you. So it's a matter of really talking with the witness and engaging them in conversation. I think now you have to be careful that you're not conducting the deposition over the telephone, but easing their mind a little bit about the process and letting them know that lawyers are human, and I'm representing somebody who has a problem, and I need your help and assistance. And
Do you prefer to do that yourself or have a paralegal or somebody else do it?
I really prefer to do that myself, John. And I found over the years, if we take it outside this scenario, you know how we all have to work with expert witnesses and
Right.
try to convince a doctor to look at a case for us, or even convince a doctor to appear for a deposition. I prefer to do that myself. And I think it's really out of respect for the witness. I'm the one that's going to question them, and I want them to feel comfortable with me ahead of time, and so that I'm not pulling any punches with them. It's a lot easier to tell someone who's working for someone else, hey, I'm not going to get involved. But when it's your case and you're the advocate, I think you have that professional duty to your client.
Now, in the scenario we saw, Ms. Jones asked a question that I think we all get frequently, is, do I need a lawyer? You handled that by basically telling her you couldn't give her advice, which of course under the ethical rules, 4.3 of the model rules, you're dealing with an unrepresented person, very careful delineating what you can and can't say. In this particular case, though, you pointed out to her that I can't tell you whether you need a lawyer, and then you moved on from that without giving her an explicit answer. What do you do when the witness, though, presses back and says, hey, you know, do I need a lawyer or not?
Right. Well, I think if you look at the ethical model rule on this subject, I don't think a lawyer can ever tell a fact witness you don't need an attorney. You could go a little bit further and say, you know, you are a fact witness, you're not being sued in this case. You could explain a little bit of that background to the witness to reassure them that really what you're doing is just conducting an interview. But I think you have an ethical duty to take it one step further and say, you know, I can't counsel you as the attorney for Mr. Tennant as to whether or not you need a lawyer. And if you have any questions about that, then you really should pick up the phone and call an attorney and ask a few questions about the process. And I think that's our ethical duty, to advise them of that.
Do you think that when you do that, you find you lose witnesses that way, and they call you back and say, I'm not going to do it? Or how do you?
No, I actually think that by telling them that, they have a little bit of trust in you in terms of, and I think that actually improves your credibility as an attorney, because they don't look at it saying, oh, you don't need a lawyer, you know, just show up, you know, for this. I'm just going to ask you a couple questions. It might create the impression that you're being a little shady, where here you're being very straightforward with them, saying, yeah, you have that right. I'm going to tell you you're only being called as a fact witness, but if you feel at all uncomfortable or you want to consult with somebody, feel free to do so.
Now, she also asked you about getting paid, which is something that certainly comes up most of the time when you call somebody. And obviously, it's a very difficult area. Some jurisdictions allow you to compensate a witness. Some jurisdictions are very strict about that. And I think anyone doing this needs to check with their own local rules. But I think it's generally understood that whatever you pay, it has to be a reasonable amount. Now, if you are paying a witness for whatever reason, and it's a reasonable amount, is it your practice to bring that out in your deposition when you're doing the direct examination?
I think so. First of all, I try to stay away from actually paying a fact witness a fee for coming in to a deposition other than the statutory fee. I might, if they've got to travel, I might give them some additional money for travel expenses, gasoline, and et cetera, in today's market, in their parking. But if I'm in that situation where really the witness says to me, look, I'm going to be missing 2 or 3 hours worth of work and I need $200, I talk to my client about that, see if they're comfortable with it, and I might pay them the $200. But if I did that, I would definitely want to bring that out in my direct examination, saying, you're being compensated today for $200. And I would ask the witness, why did you ask to be compensated that amount? And then she'd say, well, I'm taking time off of work, I've got travel expenses, parking expenses. And then it makes it realistic and credible to the jury that, yes, it's reasonable to give her this sum of money because she's taking time out of her schedule to have to come here for the deposition.
Now, another thing that you can do, sometimes works, is to explain to the witness that if they're being paid, it will somewhat undermine their credibility with the jury. And if they've become invested in the case, as you've talked about, explaining to them, why you're doing this and how they're helping get a better building or something, often you may be able to convince them that getting paid even a few $100s is not really worth the difference between embarrassment of being impeached, if you will, with that. But Ms. Jones finished by asking you a tricky question, and that was, the lawyer for the other side wants to talk to me.
Mm-hmm.
What should I do? Well, technically, I think she's asking you for legal advice.
Right.
What can you say? How do you answer that question?
I think in that situation, clearly, I have to tell her that, I can't give her legal advice. I've called her. She's receiving a phone call from another attorney. She can handle that in whatever way she feels is appropriate. I wouldn't counsel her, but I certainly couldn't say to her, well, don't talk to the attorney on the other side. I think that would be an ethical breach on my part. I think that's about as far as I can go.